The Honourable David Cunliffe.
Mr Chairman, it's a pleasure to take a short call in this committee stage of the Weathertight Homes Resolution Services Amendment Bill Part 2. Mr Chairman, this bill is yet another remedial action which has occurred because of the very serious situation around the lack of weather tightness and the difficulty that claimants have had. As has been said by several colleagues, the purpose of this bill is to remove doubt around the eligibility of certain claims in the period in which they are claimed, and the bill has traversed clauses 1B and C of a Gazette notice from 2011 and inserted them into the Act. The bill has aimed to deem certain claims eligible that were not as a result of the term built in sections 14 to 18 of the Act, as my colleague Phil Twyford has said, arising from the Supreme Court case Osborne versus Auckland Council. And that ruling has potentially allowed a number of eligible claims to be inserted, a number of additional claims to be eligible under the Act. Sir, there are a number of supplementary order papers in the bill, but before we get to that, I'd like to turn the attention of the House again to some of the clauses in Part 2, and particularly the drafting amendments in Clause 164, which are the provisions that amend the 2011 Gazette notice, and to ask the Minister if he would clarify why in Clause 2 it says, or Subclause 2, it says in Clause 1 to delete as follows: to qualify for a contribution from the Crown, all of the criteria in this Clause 1 must be met. Now, I assume, although it's not entirely clear from the revision track version of the bill, that Clause 1 is Clause 1 or Subclause 1 of 164, and which is the section in which it appears. Now, I may have misinterpreted that. It may be the original Clause 1, but I'd like the Minister, if he could, to clarify that, because it does have an important implication. If it is 1641, then we're dealing with quite a wide set of qualifications of Crown contributions, and that presumably has fiscal implications, and I'd be very interested to know how they have been quantified. The original estimates of leaky building syndrome were a Crown cost, if I recall, of about $1.5 billion, and recently I've seen estimates as high as $25 billion. And in the context of this clause, which raises the question of Crown indemnity, I think it's worth our while reflecting back on the genesis of the issue, both design problems and, importantly, the use of untreated kiln-dried timber at the request of the industry and in the absence of effective regulation from the Building Industry Authority. And that's vested here in the increased exposure of the Crown to claims and the need to make remedial amendments which clarify, sir, the importance of removing ambiguity that's crept up. And I guess that's typical. When you rely upon the common law processes, even set up under an act like this, and you have thousands of cases going through, there's going to be a whole lot of variation, a whole lot of special cases which the law didn't foresee. And there's an old saying in jurisprudence which is that hard cases make bad law, because as it evolves, the law stretches to accommodate them, and every now and again Parliament has to re-intervene, tidy up the mess as it's doing today. So, Mr Speaker, the Labour opposition supports this bill. We support Part 2. We think the amendments are necessary, and that is regrettable. But as with other pieces of legislation where we think it makes a positive difference for our community, we're not a party that would hesitate to say we support the government. That is, we're not standing on ceremony, we're not standing on party tribalism, we're trying to do what's best for the country. And we have no hesitation in saying it's sad that it got to this point, that yet another set of remedial amendments were required, such as 1641, but it's got to that point. The Minister may also wish to take a call and clarify Subpart 9, Section 165, the meaning of affected claimant. Here we are at the heart of the matter, because so many thousands of New Zealanders have been affected by it, and there has been so much ambiguity about who can claim or not. And just imagine that we didn't have the residual liability of the consenting authorities, thank you, Mr. Chairman, because so often either the designer or the construction
Honourable
company.
David Cunliffe, but with a bit of a caveat that, he has now, I think, for the second time mentioned a clause in the bill. It would be really good if he could focus on it now.
Thank you, Mr. Chairman. Very generous of you.
Really?
Mr. Chairman, the 165A brings in a person who has brought a claim under Section 9 in respect of the construction or alteration of a dwelling house for which one or more code compliance certificates were issued for the relevant building work and for whom the certificate or certificates were issued before 1 January 2012. And then a number of sub-clauses follow which impose quite stringent conditions. The Chief Executive or Chair has decided within the period starting on 1 April 2007 and ending on 10 June 2014 that the claim was not an eligible claim and that the sole reason for that decision was that the claim failed to satisfy the criteria in the various subsections which are noted 14A through 18C. And in reaching that decision, the Chief Executive or the Chair treated the date on which the dwelling house was constructed or altered as a date earlier than the date on which the code compliance certificate was issued. Now, anybody listening to that rather long and tangled exposition will note that there were about 5 ands. So while this subsection does broaden the eligibility of claimants by allowing some retrospective claims, not retrospective but earlier claims between the period 2007 and 2014, the number of specific hurdles that such a claim would have to pass amount to, I would say, quite an onerous process. And certainly in my own electorate of New Lynn, in those bushy but rather damp hills around Titirangi, we've had a number of very, very sad cases where apparently very good homes have had to be all but completely rebuilt because of the terrible effects of leaky building syndrome or a lack of weather tightness, and many of them would fit in the time period that we're talking about here. In Section 166, affected claimants are deemed to have eligible claims under the Act in respect of a dwelling house if the Gazette notice as amended applies, and the claim must be treated as eligible from the date on which it would have been eligible if the Chief Executive or Chair had originally decided in the claimant's favour. So the subsection here retrofits the decision if it passes those 5 conditions, 5 gates that we talked about in the previous section, then it effectively reconstructs the decision and allows it through as if it had been originally approved. It is messy. Sir, it reminds me of inland revenue, of income tax or other tax law, because there are always amendments upon amendments upon amendments. And we find ourselves as a Parliament once again taking up the time of the House with remedial legislation that it's doing its best to put a patch over what is in fact a very serious and difficult situation. Mr. Speaker, those are the matters that I wish to turn the attention of the House to in respect of Part 2, and I thank the House for its time.
Mr.